Welcome to this explainer. Today we're going to be decoding what is literally the ultimate showdown, the massive sweeping power of the Pakistani state versus your individual liberty. Let's think about it for a second. If your freedom was actually on the line tomorrow, would you know the rules? Because in a criminal court, you're not just risking a fine, you're risking your liberty and sometimes even your life. Okay, let's dive into this. Here is our blueprint for today. 1. Foundation. 2. The arena. 3. Anatomy of a crime. 4. The fifth schedule. And finally, 5. General defenses. Starting with Section 1. Foundation. Statutes and the Constitution.
Criminal law basically rests on these foundational pillars. First, you've got substantive law, like the PPC 1860, which actually defines the crime and the punishment. And then there's procedural law, like the CRPC 1898. That's the machinery. It governs how investigations and trials actually run. And listen, applying the wrong substantive standard, that goes right to the very heart of a conviction and can absolutely destroy a case.
But here's the thing. State power has strict limits. We have constitutional safeguards. Articles 9 through 14 protect your liberty, lay out rules for arrest, guarantee a fair trial under 10A, protect against double jeopardy, and ensure human dignity. The Supreme Court has made it crystal clear that these are fundamental rights, not just mere niceties. Moving on to Section 2, the arena, the criminal court hierarchy. Let's move to and see how this builds from the ground up. At the very base, we have judicial magistrates handling the lesser offenses. Step up, and the sessions courts take on capital crimes, like murder. And sitting right above them are the High Court for appeals and revisions. And finally, the Supreme Court as the absolute final appellate authority. Section 3, Anatomy of a crime. The rules of the game. So what actually makes a crime? The prosecution has to prove twin pillars beyond a reasonable doubt. First up is actus reus, the physical guilty act. And yes, omissions count too, but only if you have a legal duty to act. It's like a sleeping security guard on duty commits a crime by doing nothing, but a random bystander just watching? They don't. The second pillar is mens rea, which translates to the guilty mind. Did you do it intentionally, knowingly, or just negligently? This is absolutely crucial because your level of mental culpability directly dictates the severity of the charge against you. To add some authoritative weight here, the Supreme Court put it perfectly in the Emst Khanis Fatima case. Both the actus reus and the mens rea must be proved by the prosecution beyond reasonable doubt. Basically, a physical act alone, without that guilty mind, equals an acquittal. Section 4, Classifications. The fifth schedule. Now, what's really interesting about this slide is how it dictates your immediate freedom. The fifth schedule is the ultimate sorting mechanism. For a cognizable offense, police can arrest you right there on the spot without a warrant. But if it's non-cognizable, they absolutely require a judge's warrant to touch you. If you are ever arrested, lock this number in your head, 24. The Constitution strictly mandates that you must be produced before a magistrate within 24 hours. No exceptions. It is a hard, non-negotiable limit on police power. Then we have bail. In a bailable offense, getting bail is your absolute right. But here is a critical distinction. Non-bailable absolutely does not mean impossible. As the Supreme Court clarified in the Tariq Basra ruling, for non-bailable offenses, bail is simply at the court's discretion. Pakistan's system also uniquely includes qisas, which means equal retaliation. This Islamic principle actually overrides standard non-compoundable rules, allowing legal heirs to settle even capital homicide cases privately. They can choose execution, accept diyat, which is blood money, or even grant a complete pardon.
Section 5, General Defenses and Shields.
Now we're moving into chapters IV and 5 of the PPC, the escape hatches. Using one of these shields shifts the burden of proof. Unlike the prosecution's heavy burden to prove guilt beyond a reasonable doubt, the accused only needs to prove their defense is probable, just on the balance of probabilities. Take the right to private defense. You need a reasonable apprehension of danger and no time to call the authorities, but the force must be proportionate. If a neighbor is just throwing stones at you and you pick up an axe to kill them, that is criminal excess for sure, not self-defense. And timing is literally everything. As established in cases like Ghulam Hussein, your right to use force begins exactly when the threat appears, and it ends the exact millisecond that danger is neutralized. Retaliating after the threat ends, that's just a crime. What about the insanity defense? Well, Section 84, unsoundness of mind, is an incredibly narrow escape hatch. It requires a total incapacity to know the nature of your act or that it's wrong, right at the exact moment of the crime. Just having a general mental illness doesn't cut. Finally, the difference between mistakes. A mistake of fact, like an honest, reasonable mistake in belief, can be a complete shield. But a mistake of law? Ignorance of the law offers zero protection. The system presumes you know the rules. So, what does this all mean? Where do we actually draw the line between the state's massive power to punish and your right to fairness? It's a constant, high-stakes balancing act. I really hope this sparked your curiosity, because you won't want to miss part 2, where we plunge straight into the gritty investigation process. Thanks so much for joining this explainer.